Well, you know who I am. It's Omnia, and by now, you probably have noticed I dropped 5 45-ish minute videos on my channel all of a sudden. These videos all concern the court case I opened on my abuser, Kai Weiss, including all the details and evidence of his civil and criminal charges, which I have obtained throughout late 2021 and into 2022. I've been sitting on this evidence for the past 16 months, and making these videos has been my way of shining a spotlight on Kai's incessant deceit, lies, and continuous misrepresentation of the court proceedings over the past year and a half. I decided to do it this way because I thought it was the best way to answer everyone's questions in one fell swoop, and also to finally present my quote-unquote side, which is, to be fair, simply the god-honest truth about the situation. I also would like to add, most importantly, that December 3rd, 2021, which was the day of my last assault, was not the first time Kai has acted violently with me. And while this series is mainly a recount of the court case specifically, you will soon see, peppered throughout the series, the fact that he has been abusive for a long time prior to December 3rd and December 8th, which was the day he was forcibly removed from my apartment as a result of a restraining order, otherwise known as a protective order. These are all things I will be explaining in these upcoming videos, so if you're confused, that's okay. I will be walking you through it. But as of recording this, I'm not emotionally ready to give a full account of the abuse I experienced under Kai Weiss, especially throughout the duration of our relationship and before December 3rd, because I believe I still have things to process myself, and exploring that chapter of my life for the sake of a video right now feels incredibly burdensome to my mental and emotional health. If and when I ever feel up to divulging those details in the future, I will gladly share them, but as of right now, I do still believe I have more healing and processing to do in regards to that specifically. With that being said, the court case, which opened back in December 2021 and lasted until April of this year, are simply a reflection and culmination of the abuse I experienced for 11 months in my relationship with Kai Weiss. The video you are watching now is part 1 of 5, and it was completed on Saturday, May 13th, 2023. Addendums were added in on Wednesday, June 14th, 2023. Here is the video. As you may already know, the active court case I had with my abuser, Kai Weiss, which began on December 8th, 2021, just recently ended 3 weeks ago on April 20th, 2023, and well, there's a lot of stuff that has happened since then. On April 20th, I tweeted, "My domestic violence case, which has been open since December 8th, 2021, has finally concluded this morning, April 20th, 2023. My abuser, Kai Weiss, admitted and pled guilty to domestic assault and battery, which will remain on his criminal record. After 498 days, I am so relieved. Nearly 500 days of waiting and being patient in this case has finally resulted in its conclusion, and, well, like I said, I am relieved. It's been a living hell, and for many reasons outside of myself, I think I'm still living in it to a certain extent, but that's what this video is for, I guess. To be honest, me sitting here and writing a script about one of the objectively worst things to have happened to me in life is astronomically mind-numbing, and frankly, if you ask me, weird as fuck. Like, I'm really sitting here making content off of my abuse, I guess, which I honestly feel compelled to do because I have hopes of getting the truth about everything out there, but also to get these things off of my chest and mind for once in nearly 2 years. One thing I do know is that I don't want to make this video for the people who already have their minds made up about me. And if that's true for you, I hope you can find a different video that is more entertaining and fun for you to watch instead of this one. I'm not going to try and cater to the people who already hate me or have no intention of having their minds changed about what they believe about me, the case, or anything else remotely related to just my complete and utter loss of dignity over the past year. I don't think anyone except my close friends and family can really speak to or understand the sheer amount of adversity, fatigue, sadness, exhaustion, and hopelessness I felt as a result of this case, and I don't really know how I could ever convey that to anyone online who doesn't know me personally, but I also don't see a point in setting out with the intention of trying to do that in this video. I figure that if I just come forward and be as honest, authentic, true, and real as possible about everything that has happened, all that I've been through, that maybe, just maybe, I will be able to relay even an iota of what I've seen and experienced firsthand as a result of my abuser, Kai Weiss, or how he likes to refer to himself now, xzae. All I really have to say is that, once this is all said and done, once the mic is powered down and the camera turns off, I hope that something resonates with you. or something makes you think differently about what you may have believed to be true about the case or me or anything related to this. I don't really know where to begin or how to launch into the actual content of this, but for the sake of finally getting started, let me just say, hello everyone. My name is Omnia, and I used to be a YouTuber. I say used to be because I don't really make videos that often anymore, and when I do, they've kinda just been shit like this. Shit that I'm not too entirely passionate about, and shit that I felt obligated to make because it's important to debunk lies that are made about you on the internet. And it's especially important to debunk lies that are made about you and your abuse by your abuser on the internet because, well, I guess it's important to demonstrate that it can be done, and while it's exhausting, it's necessary to stand up for yourself and advocate when someone continuously pushes you too far. So, let's just hop into what I have planned for how I wish to address everything. So, a very quick recap. My life has never been the same since December 3rd, 2021. I was put in what can only be described as one of the most horrible situations of my life at the hands of my ex-boyfriend and abuser, Kai Weiss, who assaulted me, deleted my YouTube channel, and, robbed me clean after I had gotten an emergency protective order served on him. Initially, I hadn't pressed charges against him, but after repeated boundary violations and him not knowing when to stop, I moved forward with a criminal case. That criminal case has just recently ended, and that's what the main content of this particular video is about. The thing is though, I only spoke about the details relating to the case through tweets exclusively between December 10th, 2021 and March 16th, 2022. After that point, I stopped speaking about the case publicly altogether until the case concluded to preserve the integrity of the legal proceedings. Kai, on the other hand, did not. Kai has made tens of videos, hundreds of claims, and probably upwards of 1,000 tweets in the span of the entire case. I have an entire Google Drive's worth of incriminating behavior from him, and I only have this because, well, we were in a criminal case, and that's what you do. You collect evidence. And if your abuser is anything like mine, they're probably stupid enough to go on Twitter rant after Twitter rant, create videos stating that they slapped you 3 times, but that it was self-defense.
The only time that I ever put my hands on Hana was after I slapped them 3 times. I will be completely honest about that. I slapped Hana 3 times. I didn't punch them or anything like that. I slapped Hana 3 times in self-defense. I slapped them once, they didn't stop. I slapped them again, they didn't stop. And I slapped them one last time, and they stopped.
Then retracted it all, only to say that they never did it.
No, I did not abuse Hana.
Only to go on and plead guilty to the charge.
So he stood in open court and admitted on the record that he had committed an assault on you that day.
Yeah, you're gonna have a lot of evidence. And because Kai has been so loosey-goosey with what he has said and did in relation to this case for the entire duration of it, and I have not, I realized that there are a lot of misunderstandings regarding damn near everything within the case. And honestly, I never once addressed any of it. But now that the case is finally closed, and I never had my day in court, I figured, when better than to start now? And that's why this video is the first part of a series of videos where I address misunderstandings, blatant lies, and uncharitable interpretations of pretty much everything that I haven't talked about in over a year. I'm just trying to set the stage for now, but the reason I came to this decision was, 1, I figured creating a series of videos rather than attempting to make one huge video covering 16 months of allegations would make me slightly less depressed. 2, people who have questions about one particular topic would only have to watch that one video and not need to navigate a 3-hour-long video. 3, it helps me separate aspects of the case by topic and makes everything more digestible and accessible, both for me as the creator and for you as the viewer. So that's that. This will be the first video of the series. I don't know how many videos there will be, but they'll all be located in a playlist somewhere on my channel. Now, onto the actual content of this particular video. This video intends to cover the conclusion of my domestic violence court case with Kai Weiss. I will be debunking the most recent claims he's made about how this court case ended, what my prosecutor has said about me and my purported credibility, reading each term of the plea agreement, and more. This video will be guided by 2 important phone calls that I had with the main attorney appointed to handle my court case against Kai from the Commonwealth Attorney's Office. This person represented the state I currently reside in and has acted as my lawyer throughout the duration of the case. The first call occurred on Monday, May 8th, and the second occurred on Wednesday, May 10th. As I'm recording this audio, it is currently Saturday, May 13th. I did ask permission to record these calls, and my lawyer said it was fine if I posted them too. I'm keeping his name private for obvious reasons, but these were all recorded ethically, just in case you were wondering. Both of the full, unclipped phone calls should be located in the description tab under this video. If future Omnia does what they're supposed to do, it should specifically be under the important links section. I included the full unclipped phone calls here because I didn't want anyone thinking or feeling as though I was splicing up the phone calls throughout the video with the intention of hiding anything. I truthfully have nothing to hide, so if you want access to the full phone call uninterrupted, they're all right there for your viewing convenience. Now that the logistics have been squared away, let's just begin where it all started. The end. Besides the tweet I made announcing the conclusion to my court case, I didn't really say much else about quite literally anything until, well, Kai decided to drop a 50-minute long video titled, "My Court Case is Over, Let's Talk About Omnia and Kai Weiss." You know, call me an asshole, but I think it says something about how disproportionately skewed this case has been historically as well as in the present, when all I had to do was type an odd 280 characters on twitter.com for Kai to then feel obligated to drop this gargantuan-ass video less than 24 hours later. But truthfully, that's neither here nor there. I'm just being a petty little bitch. Though, I do think this is where we'll begin, because this video is what compelled me to reach out to my attorney and ask him some questions about the way this case concluded. For some context, in case you don't know, the court case between Kai Weiss and I concluded on April 20th, 2023 through Kai accepting what's known as a plea deal, plea agreement, or plea bargain. If you don't know what that is, it's essentially an agreement between the prosecutor, which is the state in this case, and the defendant, which is Kai in this case, to resolve the criminal law proceedings. This is done by the defendant, or Kai, agreeing to plead guilty to a certain crime, and the prosecutor, or the state, agreeing to provide Kai with a compromise, modification, or dismissal of other charges for doing so. Obviously, not all plea deals, plea agreements, or plea bargains work this way, and plea deals come in many different forms, but to keep it simple for you nerds, that's essentially what it boils down to. So, to recap simply, a plea agreement is an agreement in criminal law proceedings where the prosecutor provides some type of concession to the defendant in exchange for a plea of guilt. This may mean that the defendant will plead guilty to a less serious charge or to one of several charges they stand indicted for in return for the dismissal of other charges, or it may mean that the defendant will plead guilty to the original criminal charge in exchange for a more lenient sentence. Either way, this is how my court case concluded, and it's actually how 98% of criminal cases in the federal courts end during any given year. So, I'd say I'm definitely in good company. I figured I'd obtain a copy of the plea agreement Kai signed on April 20th, 2023, so we can all be on the same page about what Kai agreed to plead guilty to, as well as any benefit or compromise that was extended his way as a result of the guilty plea. Here's the plea agreement with all of the important identifying information like legal names and localities blurred. I'll read it for you. The plaintiff, which would be me as well as the state in this case, versus Kai Weiss, the defendant. Plea agreement. Comes now the state in which I currently reside by her assistant attorney, the attorney we will be hearing from shortly, and the defendant, Kai, in his proper person and through his attorney, Kai's attorney, and represent to the court that they have entered into a plea agreement, which has been reduced to writing under the provisions of rule blah blah blah. The terms of the plea agreement are as follows. 1. The defendant, or Kai, stands indicted for misdemeanor violation of a protective order, misdemeanor assault and battery of a family or household member, grand larceny, strangulation, and preventing a 911 call. 2. The defendant, Kai, agrees to plead guilty to the count of misdemeanor assault and battery of a family or household member. 3. The parties agree that the court shall sentence the defendant, Kai, to 180 days incarceration with all of that time suspended on condition of 1 year good behavior and no contact whatsoever with the victim. That's me, my legal name. 4. Upon acceptance of the plea of guilty to the misdemeanor charge, the Commonwealth would move to null pros, or essentially dismiss, the remaining charges. This agreement represents the entire understanding of the parties. The defendant, Kai, acknowledges that he has read the same thoroughly, understands all of the terms of the agreement, has discussed all of the terms of this agreement with his attorney, and is fully satisfied with his representation on his behalf. Wham bam, thank you ma'am, there's my attorney's signature, there's Kai's lawyer's signature, and then there's Kai's signature, accepted on this fine 20th day of April, 2023, signed by the judge. As you can see illustrated in terms 2 and 4, Kai agreed to plead guilty to a misdemeanor charge of domestic assault and battery in exchange for the rest of the charges he stood indicted for, and there were 7, to be dismissed. Term 1 detailed the charges Kai stood indicted for, and Term 3 states that Kai must be on good behavior for 1 year and to not violate my protective order again to remain unincarcerated. However, should he violate my protective order again or somehow otherwise break good behavior in the future, he will be sentenced to 6 months in jail. That's pretty much the extent of the plea agreement. However, Kai came out of the gate on April 21st with a bunch of bullshit about this plea agreement, and that's why I sought out to set the record straight with my attorney through these phone calls. Now, I need to make one thing abundantly clear, so tune in especially right here. My attorney throughout this entire case, and the one whose voice you will be hearing on these phone calls, was not the prosecuting attorney on April 20th. You may be surprised to hear that I never spoke a day in my life with the attorney who was prosecuting the case on April 20th. He was not my lawyer, he was not my attorney, he was simply the lawyer appointed with handling the cases from the Commonwealth's Attorney Office on April 20th. But I don't know him, nor have I ever spoken to him before. Here's a clip from the first phone call with my attorney explaining just that. Hi, it's Hannah.
How are you, Hannah?
I'm doing as good as I can be.
Did you just recently speak to...
I did. I wanted to ask before, we talk about it, if it's okay for me to record this call, just in case, because of what Kai's alleging publicly.
That's perfectly fine. The most important thing that I don't know because I don't know the timing of when the last time you talked to her. She came to me after she spoke to you and expressed your concerns. I don't know if you're aware, I wasn't even in the courtroom that day.
Oh, no, I'm not aware of that. What Kai is alleging publicly is that you said in court that my case wasn't credible enough for it to go to trial, and that's why we ended up getting the plea deal, which is not what I understood it to be. What I understood it to be was that we took the plea deal for efficiency's sake rather than fairness or justice, because the case was going on for a really long time and we would have had the case tossed out if we didn't get it done as quick as possible. And so we had to reach a plea deal. That's my understanding, but you can tell me if I'm wrong.
Well, I think that's close enough, at least at this point. Oftentimes, we send one person to court on guilty plea days because they run, anywhere from 15 to 20 cases a day.
Right.
And it's more efficient for our office to have one attorney up there handling all the cases rather than,
all of you
4
guys.
to 6 attorneys.
Yeah.
Going back and forth. So the cases that day were handled by...
Okay.
Now, I had certainly talked to him about the case, but I was not the person in the courtroom, so I can't honestly tell you what, if anything, was said, because I wasn't there.
Interesting. Well, he posted 2 videos that were an hour long each, and started watching them because I just called her maybe 3 minutes ago, and she started watching them, and she was like, oh, you need to call or legal aid because something needs to be done about this, because he's lying about the case publicly and posting it on social media and claiming you as my prosecutor said things that you didn't say, because if you're saying that you weren't even there in the courtroom, then how is it that you said that?
Well, I did not say that. I certainly did not say that in court because I wasn't in court that day. Like I said, handled the case, and I don't know what, if anything, he did say.
Okay, So then do you think I should call him?
Well, he's in a meeting right now, so I'm gonna talk with him to ask, what, if anything, was said, and then we will get that information to you.
Okay, cool. So essentially, Kai was claiming that the prosecuting attorney on April 20th, who again is not someone I ever spoke to before, claimed that I was untrustworthy and that my case was not suitable to go to trial because I wasn't credible, nor was my evidence sufficient. This is puzzling, considering I never have spoken to him. But I digress. Keeping this in mind, let's hear Kai explain his reasonings as to why he decided to take the plea deal offered to him.
The only reason I decided to take the plea deal that prosecution gave me is because, 1, I am done with this situation. It has been an entire year and some change of me and my grandmother driving an hour to and from Omnia's location to be present for court proceedings, most of which nothing happened. So now not only is this my burden, it is my family's. I am happy to plead guilty to a charge I did not commit in order to take that burden off of them. I also let this be known in court.
This is interesting considering that Kai signed the plea agreement stating that he pled guilty to the misdemeanor domestic assault and battery charge and, well, a defendant may only plead guilty if they actually committed the crime. When the government has a strong case, the government may offer the defendant a plea deal to avoid trial and perhaps reduce his exposure to a more lengthy sentence. A defendant may only plead guilty if they actually committed the crime. Let's repeat that. A defendant may only plead guilty if they actually committed the crime and admits to doing so in open court before the judge. Kai literally said he pled guilty to a charge he didn't fucking do. Did he not say that in that video? He was like, I'd be happy to plead guilty to a crime I didn't do if it helps my family. So, you're telling me the plea deal wasn't real? You cannot fucking claim a plea deal and plead guilty to a crime if you didn't fucking actually commit it. So what you're saying is you're either lying about the plea deal or it wasn't a plea deal. That's crazy. Furthermore, when the defendant admits to the crime, they agree that they are guilty. So, which is it, Kai? Are you committing an act of perjury, or are you just lying about how you did not assault me to save face online? Either way you slice it, you're lying. This also isn't substantiated in court despite him claiming he said as much. The plea agreement would never go through if Kai told the prosecution that he's quote-unquote willing to plead guilty to a crime he never committed in order to alleviate the burden the case has on his family. They simply wouldn't accept the agreement. Additionally, Kai is acting as if he is able to maintain his innocence for a crime he pled guilty to, which is not how the court of law works. This is also stated by Maxine, who is self-purportedly Kai's friend in real life. Maxine stated that the plea agreement that Kai took was an Alford plea deal in a Twitter thread with a friend of mine named Miniweets. Here is the screenshot corroborating that. Miniweets says, quote, "You're missing a very large point here. If there was no evidence, there would be no charge and no need for a plea deal. There was evidence. That's why there was a plea deal. Your friend is an abuser, brother." Maxine says, "Babes, you're the one missing a big detail. Kai took an Alford plea. Do you know what that is?" Miniweets said, "Oh my god, it was an Alford? I'm so done, LMAO. You just made it so much worse." Maxine replied, "How? Kai literally said he didn't want to go to trial, but that he was innocent. He explained his reasoning. So, of course he took an Alford plea?" Now, if you don't know what an Alford plea deal is, my attorney explained it very aptly as well as clearly, but my attorney also debunked this lie as well. Here's that part of the second phone call with my attorney after he had spoken to the prosecuting attorney.
He also wanted to make it very, very clear, and this is why I'm glad you called, that at one point the hearing seemed to be shifting a little bit towards what's called an Alford plea. And what that is in criminal law, you can plead guilty or you can plead not guilty, but you can also plead under what's called an Alford plea. And that's named after the famous case. The guy's name was Alford, in which case you plead not guilty, but you admit that had it gone to trial, the Commonwealth's evidence could have been found to be beyond a reasonable doubt to convict you.
Right.
It's a face-saving measure for some defendants. They just can't bring themselves to say, yeah, I did it. I'm pleading guilty because I did it. So they have to say, no, I didn't do it, but, they got the goods on me and I don't want to take the risk of a trial. So it looked like, according to Mr. that the case was starting to veer in that direction. But at that point, stood up and he told the court, no, I did it. I assaulted her. So he stood in open court and admitted on the record that he had committed an assault on you that day.
So it wasn't an Alford plea.
It was not an Alford plea. He just straight up stood up and told the judge, yes, I committed an assault on her. And that's now a matter of public record.
Okay, that's something I wasn't sure about because someone on social media who is in connection with him said that it was an Alford plea, but I wasn't sure and I wanted to ask if that was the case. But
no, Mr. was absolutely crystal clear with me that it started looking like it might go that way, but stood up and said, no, I committed an assault and battery.
Okay.
So it was not an Alford plea.
So that was a blatant lie on Maxine's part. I guess birds of a feather flock together if liars were birds. Oh my god, I'm so stupid. Though I think it's really funny that Kai said,
I would hardly call it admittance.
but then just
Stood up and said, no, I committed an assault and battery.
I would hardly call it admittance.
He just straight up stood up and told the judge, yes, I committed an assault on her. And that's now a matter of public record.
I would hardly call it admittance.
So he stood in open court and admitted on the record that he had committed an assault on you that day.
but it was purportedly hardly an admittance, according to Kai. The fact of the matter is, Kai cannot claim or maintain his innocence publicly regarding the domestic assault and battery, considering he did not plead guilty pursuant to Alford. He simply pled guilty, which is corroborated by both the plea agreement and the subsequent sentencing order that was placed. Additionally, the prosecuting attorney was abundantly clear in communicating with my attorney that Kai stood in open court and pled, on public record, to committing an assault and battery. So, on all accounts, Kai assaulted and battered me in my apartment on December 3rd, 2021, which is exactly what I've been claiming since the day it happened to me. He knows this, I know this, and the courts know this to be true. That's why he has been convicted for such, and there are no ifs, ands, or buts about it. It's not an allegation, it's what objectively happened. Kai Weiss is a certifiably convicted domestic abuser and batterer. You don't have to use allegedly anymore, he just is one. But Kai insisted that it wasn't that big of a deal, since it is a single misdemeanor after all. And besides, according to him, he could just get it erased from his record in like ballpark maybe a couple years or something. No kidding, he mentioned vaguely that the charge could just hocus pocus, abracadabra, be absolved in some random time frame.
2. The charge has been lessened to a misdemeanor. Otherwise, my record is clean. So when it comes to looking for jobs, there's no real issue. I also consulted my lawyer about this. Some may deny me, but overall, I'm pretty fine. I decided it's a great compromise as opposed to going to trial, which is a very expensive process, and it's way better than what Omnia wanted me to take. Also, to add, I can get the charge expunged from my record, and it automatically expunges after a couple of years, so I didn't really think it was a big deal.
But again, that's not true. Here's me asking my lawyer about it. Kai's also alleging that the domestic assault and battery misdemeanor charge is going to be expunged from his record eventually.
Absolutely not.
That's not true.
It's not true.
So it will stay on his record.
It will stay on his record permanently.
Okay.
That was a big part of the whole point of it.
So it's staying on his record.
Yes, he just has a flat-out conviction. You can't expunge convictions.
Okay, so he's just been lying then.
Or mistaken, I don't know.
Okay.
A lot of people don't understand these kinds of things, but no. He just has a flat-out conviction. There was nothing in the agreement about agreeing to expunge anything, and the law wouldn't allow it in any event.
Damn, is anything Kai say in this video founded in reality? Kai goes on to explain his third reasoning as to why he took the plea deal offered to him.
3. The sentence was completely suspended, meaning I spend no time in jail whatsoever. So despite the charge being on my record, I'm a free NB. And that's all I wanted. I can do whatever I want now.
Yeah, okay, Kai can do whatever he wants, except violate my protective order again, or else he'll be subject to 6 months in jail according to that same suspended sentence he's referring to.
4. This disproves every other accusation toward me and adds credibility to what I've been arguing against for coming up 2 years now. If there was sufficient evidence, the charges wouldn't be dropped. I would still be given the same plea deal and we would have went to trial. But that is no longer necessary due to prosecution and my decision to take the deal.
Man, this clip is my favorite by far. This is just a blatantly untrue statement as well, and it really goes to show how little Kai understands the most basic of understandings when it comes to what a plea agreement is, how they work, and why the courts utilize them at such a high frequency. In any given criminal case, the prosecution and defendant entering a plea deal doesn't imply any negative moral judgments about the credibility of the case. If anything, entering a plea deal is actually an indication that the state has a strong case against the defendant. As we've spoken about ad nauseum earlier, all a plea deal really is an agreement between the defendant and the prosecutor in which the defendant agrees to plead guilty to some or all of the charges against them, once again in exchange for concessions from the prosecutors. It's a deal. That's all it is. These deals also allow prosecutors to focus their time and resources on other cases and increase the court's efficiency. Let's dumb it down to its most basic principle by utilizing an example. Let's say you see a guy shoplifting at a store. What you could do is tell him, "Hey dude, I'ma rat you out to the police and get your ass arrested." Or you could say, "Hey man, I saw you stealing from the store, but how about I cut you a deal? Instead of ratting you out to the police and getting you arrested for shoplifting, why don't you know, go ahead and snag me a little something too. And I promise to keep this whole ordeal hush hush. You win because you won't get ratted out, and I win because I get a little free something that you steal from me." The second scenario would be more reminiscent of a plea deal, and here's how. Just because the shoplifter doesn't get told on doesn't mean the shoplifter didn't do something illegal. It means the authorities don't know about the crime because a deal was cut between you, the potential whistleblower, and the shoplifter. Similarly, just because Kai's charges got dismissed as a result of the plea deal doesn't mean Kai didn't commit the crimes he stood indicted for. It just means that he wasn't found guilty on those charges because a deal was cut. It's that simple. Editing Omnia here, I wanted to add something that I think might provide some additional context. So Kai is not incorrect that one of the reasons why a prosecutor may dismiss charges against a defendant is because of insufficient evidence, but that is not a full representation of the reasons why a prosecutor may decide to dismiss charges. Here's an article which states that nolle proseque is a Latin term that means will no longer prosecute. When the prosecutor asks the court to grant a nolle proseque, they are requesting that the criminal charges be dismissed. They could decide not to prosecute you for these reasons. As Kai mentioned, 1. There is insufficient evidence to prove your guilt. 2. Witnesses are no longer available or unwilling to cooperate. 3. New evidence has been discovered. 4. Your charges were minor and you corrected the violations. And 5. Dismissal by nolle proseque is part of a plea agreement. This is important because while yes, insufficient evidence might be one of the reasons prosecution may move to dismiss the charges pending against the defendant, that is not the only reason. And the main reason why Kai's charges were dismissed was because it was part of the plea agreement, as we stated earlier. I highlighted the 2 conditions of the plea agreement that makes this abundantly clear. Condition 2 states the defendant agrees to plead guilty to the count of misdemeanor assault and battery of a family or household member. And condition 4 states upon acceptance of the plea of guilty to the misdemeanor charge, the Commonwealth would move to null pros the remaining charges. Condition 4 clearly states that only if Kai accepts the plea of guilty will the state dismiss the rest of the charges, which illustrates that the charges were dismissed as a part of the plea agreement, or the 5th reason why prosecutors may decide to nolle proseque. To add more context and further solidify that the charges were not dismissed because of insufficient evidence, Kai would not stand indicted for all the things I alleged he did to me had there not been sufficient evidence to indict him. Kai is blatantly misrepresenting the conclusion of this court case by insisting I didn't provide sufficient evidence for the claims I've made, but if anything, the charges were dismissed in exchange for a plea of guilty to the domestic assault and battery charge. Just thought that this would be helpful to add. The whole premise of plea deals is to increase court efficiency. It has nothing to do with whether or not my case was credible. Kai also keeps going on about the fact that while yes, Omnia may have established probable cause, Omnia has never established guilt. And pardon my lack of manners, but duh, that is impossible for me to do if you literally decided to take up a plea deal instead of going to trial. How is one supposed to establish guilt in a legal case if 1, the defendant doesn't plead guilty in a plea deal to to those charges, or 2, we don't go to trial in order to hear testimony from, question and cross-examine witnesses, submit evidence, and offer statements on all charges the defendant stands indicted for. Besides, the only reason we didn't go to trial is because Kai and his lawyer asked for a plea deal 9 days prior to the scheduled jury trial, which was set for February 16th this year, and my attorney, as part of the Commonwealth's office, complied. Here's the consent order of continuance, which states that on February 7th, 2023, quote, "This day came the parties to this case and hereby requested that the court issue an order continuing this matter to Monday, March 6, 2023 at 1 p.m. for status or entry of a plea. The parties requested that the court release the jury trial currently set for February 16th, 2023. Wherefore, upon the agreement of the parties and for good cause shown, this matter is continued on joint motion of the parties to be set for status or entry of a plea on March 6, 2023 at 1 p.m. The jury trial currently scheduled for February 16th, 2023 is released." And there is the judge, my attorney, and Kai's attorney's signatures below. So if Kai really wanted me to establish guilt in court, he would have declined any offer from the Commonwealth's attorney's office or otherwise to take a plea deal, but he didn't. So Kai can't get upset at me for not being able to establish guilt when he didn't even want to give me the opportunity to do so in court. Last point about this and how the plea deal does not disprove every accusation that was dismissed or say anything about my credibility or lack thereof. Here is my attorney agreeing with the fact that the deal had nothing to do with my untrustworthiness or incapability of presenting solid evidence and had everything to do with efficiency. What I understand is that most criminal cases end in a plea deal. 98% of cases end in a plea deal. So it's not that I didn't prove probable cause or that I didn't have enough credibility for it to go to trial. It was just more efficient to go with a plea deal, correct?
Yes, and in this case, I think that's a fair way to summarize it.
Kai really be speaking out his ass this whole time. Finally, to tie up this video as well as the first part of this series, I think we should play the part that Kai opens the video up with, since I guess a common theme of this video is that everything is being done out of order. We started with the end and now we end with the beginning. It's just so poetic. Kai starts his video off with this clip.
So the reason for the agreement is, in discussions with, had some instances where she may not have been truthful with him. Those were all disclosed and turned over to. It likely would have been information that could have been used to cross-examine her in front of a jury. The defendant has no prior convictions and does document the domestic assault. The victim is not supportive of this agreement. She does not agree with this result. She has been consulted. It's in the exercise of our discretion and the likelihood of what would likely happen in front of a jury. It does document the domestic assault. It's obviously, if what she said happened, it's extremely serious, but it's just sort of one of those tough cases. This is the best call we can make in terms of what a just result is. Again, she is not supportive of this. We have an idea of what would happen in front of a jury, but this seems like a fair resolution from the Commonwealth's perspective. These are the words from Omnia's prosecutor on April 20th, 2023. I'm actually writing this on the day I have just left court. Later, after this was said, the judge clarified that if this case was litigated, there would be a number of credibility issues on Omnia's end. Prosecution also confirmed that.
This is crazy, considering no one, not even I or my lawyer, knows exactly what Kai is citing or where Kai got this from. I'm assuming half of it is what he remembers was said in court on April 20th, and the other half is just utter bullshit, probably. Because, like I've said throughout the entire duration of this video, I have never spoken to, met, or even know who the prosecuting attorney who was handling the guilty plea agreement on April 20th was. So for Kai to allegedly quote him saying that I was not truthful with him, that I am not supportive of the plea agreement, that I do not agree with the result of the case, and that he had consulted me and knew that I was unsupportive is buck wild. Again, never spoke to this prosecuting attorney a day in my goddamn life, never was consulted about whether or not I supported the plea agreement, and frankly, I didn't even know this guy's name until my phone call with my attorney. I asked my attorney if he knew anything about what this prosecutor allegedly said in court, and this is what he said.
May I help you?
Hi, Tana.
Hey, how are you?
I'm doing well. How are you?
I'm doing just fine. What can I do for you?
I had a follow-up question to the last call about... and whether or not you were able to speak with him?
So I did speak with him, and I apologize because I never know if I'm catching you before or after you've also talked to...
Oh, I haven't talked. The last person I talked to was you on Monday, I believe.
Okay. So I did confirm that it was Mr. in the courtroom that handled the guilty plea.
Okay.
He did not recall absolutely everything, but he did recall that one of the issues in the case was that he remembered the issue with the cat.
Mm-hmm.
And then it went to that lengthy protective order hearing.
Right.
And he was able to demonstrate that he brought the cat to the relationship.
Yes.
So that was something that we did have to disclose to the defense. So he may have said something to the extent that in the course of the prosecution, certain evidence was disclosed that could have been used in cross-examination against you.
Right.
But that's all he would have said.
So, essentially the only thing that sounded anything remotely like that from what Kai was allegedly quoting from the prosecutor is this part, where it just says, "This likely would have been information that could have been used to cross-examine them in front of a jury." That is the only thing in that entire paragraph that sounds like what my attorney said the prosecutor would have mentioned. But, you know, I was still curious, so I asked. Okay.
Okay.
Yeah, the only other thing is, I don't know if you have this information or if it's like publicly available, but is there a copy of the court transcript from April 20th or no?
There is not. Now, it was recorded. If you want a copy, what you would have to do is call here and give them the name of the case and the date and the time.
Okay.
And for a fee, they can prepare a transcript for you.
Oh.
I don't know how much the fee would be.
Okay. Well, I can call just to see. Do you know their number?
I do not off the top of my head. You could also contact the circuit court and get a copy of the sentencing order.
Okay.
Because that'll tell you if he were to plead not guilty pursuant to Alford, it would be in the order.
Okay, so I could just call circuit court and get a copy of the sentencing order for free?
Yeah, it's a public record.
Okay. Do you know the circuit court's number by any chance?
Not off the top of my head, but if you just Google circuit court, it'll come right up.
Okay, thank you. That's it.
Very good. You have a good rest of your day.
You too. Thank you so much.
Bye.
Bye. Now, I've reached out to the office that has the court recording from April 20th, both by calling and leaving a voicemail, as well as emailing. I have yet to hear back from them as of today, Saturday, May 13th, but I'm hoping they can get back to me at some point during the work week. I know I'll probably be posting this video prior to hearing back from said office, but I'll add an addendum in the near future when and if I'm able to obtain the court transcript from that day. I think it would be really helpful to have, considering I wasn't in the courtroom that day, my attorney wasn't in the courtroom that day, and the only other people present were Kai's attorney, and the prosecuting attorney that I once again never consulted with, talked to, or met. Hi, editing Omnia here. Sorry, I just want to add one more thing. I mentioned how Kai's lawyer, and the prosecuting attorney, along with the judge, are the only ones that I'm aware of who were present for the April 20th court hearing, and because my lawyer asked the prosecuting attorney what happened, and he said that he didn't recall everything.
He did not recall absolutely everything. But
the only other people that could attest to what happened in the courtroom that day is Kai and his lawyer. And Kai, as proven throughout this entire video, is not a trustworthy source of information and cannot be taken at face value for much of anything. So the reason why I would want a court transcript of that day is because I don't trust anything that Kai has to say, because he is not credible and he has been known to lie multiple times. However, like I said, I'd be more than willing to share the court transcript when and if I get it. Oh my fucking god, I said that the last editing Omnia moment would be the last one, but here I am again. Hello, Jesus. Today is June 14th and it's 11 o'clock at night, just bear with me here. I finished creating this video back on May 9th, but I'm here with the addendum I promised. I'm so tired. I haven't heard anything from the office that records court proceedings. They never answered any of my phone calls, got back to my voicemails, or replied to my emails, so I still have yet to hear about anything regarding the court transcript. However, about that sentencing order my lawyer was talking about,
You could also contact the circuit court and get a copy of the sentencing order.
okay.
Because that'll tell you if he were to plead not guilty pursuant to Alford, it would be in the order.
Yeah, I got that. I think it's very straightforward and written in plain English, so I'll just read it to y'all, and I think you'll not only have a better understanding of how this court case concluded, but also you'll quickly realize how full of shit Kai is 100% of the time. Arraignment, conviction, and sentencing order in the circuit court for the city of my locality. The hearing date was April 20th, 2023. The state versus Kai White. This case came before the court for arraignment and sentencing of the defendant who appeared in obedience to his own recognizance with his lawyer, and the Commonwealth attorney represented the Commonwealth. Thereupon, the defendant, pursuant to a plea agreement executed and dated April 20th, 2023, personally entered his plea of guilty to the charge of assault and battery of a household/family member as contained in indictment number blah blah blah.
I would hardly call it admittance.
Whereupon the court, having ascertained on questioning the defendant that she fully understood the serious nature of the charges herein pending against him, the extent of the punishment which may be imposed therefore, the effect of pleas of guilty, including on his right of appeal and his right to a trial by jury, and the court finding that the defendant's pleas of guilty and waiver of a jury were freely, voluntarily, and intelligently made, proceeded upon the said pleas of guilty to hear and determine this case without the intervention of a jury as provided by law. And the court, having fully heard the evidence and argument of counsel and having maturely considered of its judgment, finds the defendant guilty of the following offenses: assault and battery of a family or household member, misdemeanor, offense date December 3rd, 2021.
I slapped Hana 3 times in self-defense.
The court hereby accepts and approves the plea agreement and finds that it is reasonable, that there are substantial facts and circumstances in the case to support it, and that it serves the ends of justice.
No, I did not abuse Hana.
Before pronouncing the sentence, the court inquired if the defendant desired to make a statement and if the defendant desired to advance any reason why judgment should not be pronounced. The court, in accordance with the plea agreement, sentences the defendant to confinement in jail as follows. Sentence imposed 180 days or 6 months. Sentence suspended 180 days. On good behavior, the defendant shall be of good behavior for a period of 1 year to commence immediately. The defendant shall keep the peace and obey the law and anyone in lawful authority over him. During this period, the defendant shall have no contact whatsoever with the victim, me. Costs. Execution may issue upon the fines and costs not paid at the imposition of sentence, in this case in accordance with code whatever. The defendant, if unable to pay the fines and costs upon the imposition of sentence, must request the court for approval of deferral of the payment of the fines and costs pursuant to of the code as amended. Credit for time served. The defendant shall be given credit for time spent in confinement while awaiting trial pursuant to code. The court, on the motion of the Commonwealth attorney, enters a null pros to the charges of violation of a protective order, grand larceny, strangulation, and preventing a 911 call as contained in case number respectively. The judge signed this paper on May 23rd, 2023. That concludes this video regarding the lies, misunderstandings, and otherwise misinformation about the conclusion of my court case. The next topic I would like to cover is all things regarding my protective order, including its provisions, how the cats were involved in it, renewing it, appeals, motions, and violations. I don't know when that video will be completed or ready to be released, but I am graduating from college this upcoming weekend, so I highly doubt that video will be ready by the same time next week. Hate to break it to you, but I too have an outside world I need to attend to, but hopefully that video won't be too hard to churn out. Until next time, stay snazzy sexies. Bye!